Hey, good morning. Welcome back to sunny Canberra, where I need to actually have the curtain closed behind me so that you can see my face. Hope it's not too dark. And as seems to be the case when I'm traveling, I'm having technology issues, but we're going to get them sorted. So in this video, my plan is to talk to you about legal professional privilege. I mentioned in the introduction that I'm actually going to incorporate another video into this lecture. I am actually, let's see how we go as to where it fits in. Believe it or not, I need to do a lot of preparation to make things look quite this shambolic and just see where it fits. Again, it is a little bit old, but I think it will really get us thinking about the ethical issues in practice when it comes to legal professional privilege. I have to say that the situation that the lawyers in the video are in is one that I've never even come vaguely close to. And I hope it is a somewhat unusual circumstance. But because it is so significant, it really does make us think about where the boundaries of this privilege might lie. And if we look at it through the different lenses of comfort, for want of a better word, that we have, I think we'll have a much better understanding of our own position and what this means for our own roles as ethical lawyers who are required to follow the ethical rules. Not always the same thing, I guess. So let's talk about privilege. Privilege is something that is the stuff of law and order plots. It is the stuff of TV shows. It is the lawyer's version of the secrets that need to be held in the confessional. So before we get stuck in too much, remember that this has been around for a really long time. The idea of privilege goes back to the 16th century. So it was originally a privilege that belonged to the lawyer, and a theme that you'll see coming out through your reading significantly is the way that there has been a shift from the privilege being something that belongs to the lawyer through to something that is clearly the right of the client. Now, in legislation now, it's no longer even referred to as legal professional privilege. It tends to be referred to as client privilege, really to highlight this idea that it is something that belongs to the client and can only be waived by the client, even though it is actually claimed by the lawyer, because clearly the lawyer is the one that's in the position to understand when it applies and to manage that process. This idea that we've spoken about a few times along the way of the moral hazard, really, the economics concept of the moral hazard really plays in here, where the lawyer has more information, knowledge and experience than the client, so can't really wait for the client to tell them that they want to maintain privilege. They need specific and informed consent to release the privilege. So before we even really talk about what it is, let's talk about why we have it. And ultimately, I think the key rationale behind it, and look, the bullet points on the slide, for those of you listening along on a podcast rather than looking at the slides, pull up the slides because they've got quite a lot of text on them and they will be helpful to you this time around. There's kind of a number of bullet points of reasons why we have privilege, but the key one ultimately is that the lawyer needs to have all of the relevant information in order to make rational and informed decisions about the way that the law applies to a client's situation. And they can only do that when they have all of the information. The lawyer is better placed than the client to make sense of what information is relevant and what information is not relevant. But if the client is concerned that if they give the lawyer all of the information that they need, that the lawyer will basically take them to the police or think less of them or deal with them in some different way, then there will be some real concerns about that ability. There'll be some real reluctance, is probably a better word, a real reluctance to share candidly all of the facts that may be relevant to the matter. So ultimately, by providing this idea of privilege, essentially ensuring that a lawyer is required to maintain the confidentiality of information, even if the information might be relevant to court proceedings. As long as the lawyer is honest, actually, the way that I started to say that could be misleading. So let's backtrack a bit, because there are differences between the duties that one has to the court. So the lawyer is required to deal with the court honestly, but that doesn't include a requirement to disclose information that falls within the privileged area. So if information that the lawyer has that is privileged, for example, demonstrates that their client may be guilty of a particular accusation, provided that they deal with the court in an honest way, they won't be breaching their duty. They don't have to disclose that information. They may not be in a position where they can assist the client to plead not guilty, although in many cases they will be, because it's up to the prosecution to prove the facts. They certainly won't be required to disclose facts that are privileged. So the reason for this is really to ensure that the lawyers are properly informed, and so the basis of privilege sits in this idea of access to justice. There are a range of other arguments, including that it discourages litigation and encourages alternative dispute resolution, that lawyers who have all of the facts, particularly in commercial matters, will be well placed to assist their clients to come to a negotiated resolution of a matter. It also protects the privacy of clients, but ultimately the access to justice, the benefits of full disclosure are really the historical and ongoing benefit. And while it's a little while ago, I think it still remains relevant. There's an Australian Law Commission report that looked at privilege, and it's something that I suggest that you have a look at to think about how modern day privilege sits in this historical context, and how lawmakers have thought about privilege as they've been providing the statutory equivalents. So this charming fellow here, Justice Michael Kirby, referred in Daniels Corporation to legal professional privilege as being an important human right deserving of special protection for that reason. The right to properly inform and advise one's lawyer without fear of prosecution, without fear of that information being shared, is described by Kirby as a human right. I'd be interested to know whether you think it should go that far to be a human right, as opposed to simply a legal right. Now, all privileged information is confidential, but not all confidential information will be privileged. So it's worth thinking about it like this, that as lawyers, we owe a duty of confidence to our clients, but the law only seeks to protect at the ultimate level information that is not only confidential, but also privileged. And so in order to ensure that we can distinguish between confidential information, and we're bound to keep confidences by the duty, usually by the terms of the retainer. We'll talk more about the retainers in week 8, and by the general, both the written terms of the retainer, but also the common law implied terms of the retainer. Privileged information takes a special status. It is protected as a matter of our duties to the court as well as our duties to the client. That it is a fundamental duty of the lawyer to maintain the confidence of clients in relation to privileged information in particular. And there are 3 distinguishing features that help us identify the information that is privileged. They go to the source, so where the information came from, the scope of the obligation itself, so the extent to which it relates to advice or to litigation, and the consequences of the obligation, what that means for the way that we as lawyers deal with our clients, deal with the courts, deal with third parties. And all of these ideas will come out, if not entirely this week, over the next couple of weeks or next couple of sessions, because you do have a break in between. So again, another way of thinking about the rationale of legal professional privilege, you'll see it, the acronym LPP, used religiously, it seems, across the profession for when we're talking about privilege. Comes from Justice McHugh in Carter and Northmore, Daly and Leake, where he said that the best explanation of the doctrine is that it is a practical guarantee of fundamental constitutional human rights. Again, like Kirby, human rights. By protecting the confidentiality of communication between lawyers and clients, the doctrine, notice this use of the word doctrine too, it's the client has the right, but the law is referred to as a doctrine quite regularly. So the doctrine protects the rights and privacy of persons, including corporations. So when we're talking about persons here, we're talking about legal persons. And this can be really important because the ownership and management of corporations changes, but the obligation will continue to be owed to the corporation when the corporation is our client. So the doctrine protects the rights and privacy of persons, including corporations, by ensuring unreserved freedom of communication. I've highlighted those words on the slide. And I think communication in particular is important. Well, we're going to talk a lot about documents, and clearly documents are communications. The doctrine of legal professional privilege relates to communications. So by ensuring the unreserved freedom of communication with professional lawyers who can advise the client of their rights under law and, where necessary, take action on the client's behalf to defend or enforce those rights. The doctrine is a natural, if not necessary, corollary, a word I can never say, corollary of the rule of law and a potent force for ensuring that the equal protection of the law is a reality. So again, McHugh is really linking the doctrine of legal professional privilege to access to justice. I mentioned before that the ALRC, the Australian Law Reform Commission, probably should have capital letters in its name there because it's a proper noun on the slide, sorry about that, has back in, I think it's 2011, please check if you're citing it, because clearly my citation there is incorrect, because I would be able to guess if I had what the year was, but my memory is it's 2011, so quite some time ago now, recommended, and subsequently this was adopted, the term client legal privilege, because the privilege is now clearly held by the client and not the lawyer. And we see this is played out in the Commonwealth legislation and in New South Wales and Tasmania, where the Evidence Acts incorporate this idea of client legal privilege or legal professional privilege. That terminology is used. In the common law cases, though, you'll almost universally see the terminology legal professional privilege used. From a research point of view, it might be worth noting that because it gives you two sets of keywords to search for: client privilege and legal professional privilege. So where do the obligations come from? I said I'd talk about the sources. So we've got both common law and statute. Oh, sorry, I've clearly got some animations in there that I forgot about. For those of you listening along at home, that was ridiculous, and now I've wasted even more time by mentioning it. Anyway, moving right along. Let's talk about common law first. There are two limbs to the common law doctrine. Two types of privilege: advice privilege and litigation privilege. So advice privilege is essentially the protection of communications between a client and their lawyer for the purpose of the lawyer providing advice. And again, pretty clear and straightforward. We need a fulsome disclosure of all of the facts so that we're confident we can give you the right advice. Litigation privilege, now this has gone through the ringer a couple of times and more around what it actually entails. It's clear that litigation privilege relates to the protection of communications between the client, the lawyer, and certain third parties, where the dominant purpose of the communication relates to anticipated or existing legal proceedings. So this is often the dispute and the question that you'll come across not an unusual question in an exam, I might point out, is the extent to which a communication that is prepared by a third party, so a witness or potential witness, for example, so a medical report or a report that is being prepared by a surveyor or an engineer or some expert in the way that a product or a drug should work. If that report is being prepared for the dominant purpose of anticipated or existing litigation, then it should be. If it meets the test, then it will be legal professional privilege. Often the disputes in relation to client privilege or legal professional privilege really relate to whether or not this third-party document is caught within the scope or outside of the scope. Now, the current test is that question of dominant purpose, and I'll talk about that in a bit more detail already. The previous tests have required it to be the sole purpose, a harder test to meet, but an easier test to understand. But remember, the other sources of obligations include our confidentiality obligations under the retainer as a consequence of the equitable relationship that lawyers have with their clients, so the fiduciary nature of the relationship. Equity I've just mentioned. Of course, there are also professional conduct rules, and I would very much suggest that you have a look at those. So the Australian Solicitors Conduct Rules, which are now part of the Uniform Law or part of the Uniform Law Conduct Rules. So 9.1 and 9.2 for solicitors, and the Barristers Rules 63 will be really informative for you in this way. And then also, when we're thinking about the sources, when it comes to the statutory idea of client legal privilege, which we'll see in the Evidence Act, again, just bear with me for a minute. I'm throwing a lot of information at you. I'm hoping it'll all come together, is really this public policy access to justice argument, and it plays out in Federal Evidence Act in sections 118 and 119. And again, I'd strongly recommend that as part of your notes and exam preparation that you have access to those sections along with the profession rules, because if there's a question about legal professional privilege, and there often is, I'm not promising there will be, but there often is, they will be very, very helpful to you in negotiating any problem relating to that. So as I mentioned just a second ago, under the common law, there are two limbs, this advice privilege and litigation privilege. I think I pretty much explained everything that's on this slide when I was talking through it in the last time. And it is actually, again, a slide like this will be helpful to you as you are negotiating an exam problem. Take a minute to kind of soak it in. And as a strategy, when you're thinking about privilege, there is real benefit early on in actually examining, is this advice privilege? Are we talking about advice privilege here? Or are we talking about litigation privilege? And what would that mean? Where does it fit? So clearly, regardless of whether we're talking about advice or litigation privilege, we need to understand what the purpose of the communication is. Pretty sure I mentioned this before, but it is worth remembering that these are communications. So while documents are often the subject matter of the case, you'll find that it's all communications, including verbal communications, and even communications by inference. Most communications, particularly in commercial matters, will be documented in some way, and it's worth remembering that the Electronic Transactions Acts and electronic communications rules in each state will include, amongst the idea of documents, electronic communications, including not just email, including text messages, TikTok, Snapchat, Zoom meetings, team meetings, Slack communications. All of these things will be communications. So again, thinking about this in the context of the work that we've done earlier in this semester, we do need to think about the ways in which AI not only needs to be trained to discover in a pretrial context or in a due diligence context, important communications. It also needs to be trained to identify the communications that most likely need to be protected under the doctrine of legal professional privilege or client professional privilege. So the key case in relation to what was previously known as the sole purpose test was Grant and Downs. And in that case, ultimately, the doctrine was limited, or following that case, it was limited to a lawyer's ability to claim privilege on items that were not for the exclusive purpose of the client's case. But under the current test, which really came out of ESO Australia and the Commission for Taxation, the current dominant purpose test provides a much broader scope of legal professional privilege. So let's talk about what that was. I think I doubled up my negatives there, by the way. Sorry, just reflecting back on what I said, just to be 100% sure, that Grant and Downs limited a lawyer's ability to claim privilege on items that were for the exclusive purpose of the client's case. The slide that I'm looking at the moment while talking to you is incorrect, that you will see on the screen is incorrect, but hopefully I remember to edit it before I send it to you, and those of you reading by the podcast, watching with the podcast, will be like, what's she talking about? Okay, just fast forward me. I hope I'm in chipmunk speed anyway. So what is the dominant purpose? Let's talk about dominant purpose. So in ESO, essentially the test can be refined as follows. Only confidential communications made for the dominant purpose of securing legal advice for use in existing or reasonably anticipated litigation can possibly be privileged. So we can see the test. Communication must be confidential. So a chat that you had with somebody on a panel discussion, even if Chatham House rules applied to that panel discussion, cannot be classed as a confidential discussion, a confidential communication. But a quiet conversation in one's office that you bill for, by the very nature of the retainer, would definitely be a confidential communication. Then the question is, what is the dominant purpose? So it doesn't have to be the only purpose, but it should be the dominant purpose. So one of the things that we see happening in legal practice is a separation out, a letter that requests a report from an expert. So, for example, a medical report about a plaintiff's condition might be sought with very specific instructions to the doctor that the evidence may be used in connection with a piece of litigation being brought or being defended by one's client. And you might actually have 15 other questions you want to ask that expert at the same time that have nothing to do with the litigation. Again, it is prudent as a competent lawyer to separate out those communications so that both the request for information that relates to the dominant purpose of litigation can be separated out from the more general stuff like, how's your day going, mate? And also that it is clear that it is for use in existing or reasonably anticipated litigation. So as you work through Del Ponte in particular and you look at the cases there, you'll see that's a theme that comes up very often. Could one have reasonably anticipated that action was going to be taken in relation to this matter? Now, a lot of the cases here come out of the tobacco disputes of the 1990s and early 2000s, where essentially firms that had information about the damage that tobacco did or asbestos did or similar kind of dangerous products were destroying that material or claiming privilege over that material. And so the question became, could they have anticipated that litigation was likely? And how do those general requirements both to disclose information that is relevant to the case sit with the protection of information or communications that have been gathered for the dominant purpose of addressing some potential litigation. And I find that really fascinating. I'm not a litigator, and I know your tutor has significantly more litigation experience than me, and most likely much more interesting stories to tell about how that plays out in real life. But it does. This is a really good example of where that conflict can come up and really pull against the different ethical frameworks, where somebody who approaches the ethical rules as a zealous advocate might address the outcomes of this kind of discussion quite differently from somebody who approaches these rules as a moral activist, for example. Also, it's worth noting that this is reflected now in the legislation. So there's the Federal Evidence Act, or the Commonwealth Evidence Act, ensures that confidential communications created for the dominant purpose of providing legal advice or litigation are protected from disclosure in the federal courts, and the identical wording is used in the New South Wales and Tasmanian Act. For the other states, we are looking at ESO as being the leading authority in this space, and it's a common law requirement. It is worth noting, though, that in some states, including Victoria, there have been amendments to the Evidence Acts that carves out certain types of information in certain ways from destruction, at least. So, for example, certain types of, like where there is anticipated litigation, there is a general requirement that information be maintained, even though as otherwise, if there were no possibility of litigation, that information might be able to be destroyed in 5 or 7 years, depending on the relevant regulation. So a little bit more into the dominant purpose test. I'm just going to do a quick scan here. I think really this slide is really text to help you with what it was that I was trying to explain to you in the last, when I had the last slide open. I don't think I'm going to do a better job of it. I think in this slide and in the cases, there is value in reading Grattan Downs so that you understand the evolution that you see in ESO. But if you only read one of them, read ESO because it is the leading authority in this case. Some of the stuff to look for, the term dominant in this context means the ruling, prevailing, or most influential purpose. So the number one reason for obtaining the information or making the communication. It's also important that you satisfy the court that the advice or litigation was one of the purposes of the communication. Is not just one. It needs to be the primary or dominant purpose. So you need to show as a matter of objective fact that the purpose dominated the decision to make the relevant communication. And it's important to be able to show that the communication would have been made irrespective, I'm just doubling up my negatives today. If the decision to obtain the information would have been made if there were no litigation in place, then the fact of the litigation becomes not dominant. You need to be able to show that but for the litigation either being anticipated or being commenced, that communication would not have been made or sought. So, as I mentioned before, 2 limbs, litigation privilege and advice privilege. For litigation privilege to apply, the communication must have been made for the purpose of use in existing or reasonably anticipated litigation. So again, the dominant purpose test applies. Key case, Mitsubishi Electric and Victorian Work Cover Authority. So the litigation has to be more a mere possibility, but it doesn't have to be more likely than not. The question for dominant purpose is, if I wasn't worried about the potential for litigation, would I have made or sought this communication? So, with advice, clearly litigation becomes not relevant. So the dominant purpose becomes legal advice. Much clearer test. It's really a question of, did I give you this information because I was seeking legal advice? If I did, the protection avails itself. So again, I want to make sure that we're clear on what kind of communications aren't covered, and basically work on the basis that if something moves from somebody's mind to somebody else's mind, somebody is able to read it, hear it, understand it, then it is a communication. Client professional privilege applies to all communications, not just documents in a written form, even though most of the things that we end up seeing in the cases are written form, of course. So notes, drafts, charts, diagrams, photographs, spreadsheets, anything that is compiled for the purpose of marshalling that information that is subject to a confidential communication. It could be oral. It could be mechanically, electronically, or video recorded. Like I said, Snapchat, TikTok, a note on a email or a handwritten note on a document. It could be something that is said in confidence. The question is there a communication? Is it confidential? Is it sought for advice or litigation? Particularly if it's for litigation, was the dominant purpose pending or anticipated litigation or actual litigation? So again, pretty complex, but straightforward at the same time. Now, we've said this a number of times, but it is also important to remember that privilege belongs to the client. Only the client is entitled to claim the privilege. And this is because it's in the client's interest, not the lawyer's interest, and also in the broader public interest that privilege is there to protect the client. Of course, for the reasons I mentioned earlier, it is the lawyer who claims the privilege on the client's behalf. And of course, it is the lawyer who is best positioned to determine which communications are covered by the privilege, also to work strategically to maximize the communications that might be covered by privilege as well. A lawyer's duty is to ensure that a valid claim for privilege is not lost. And so lawyers have a duty to ensure that only non-privileged communications are disclosed, including in compulsory processes. So again, this becomes an issue when we're dealing with technology-assisted review in a due diligence or a litigation context, is ensuring that we don't inadvertently let privileged communications slip through the cracks. And it can be very, very difficult and time-consuming as individuals to look for those communications and withhold them, particularly when you think about the amount of data that we transfer and we share these days, and the ways in which we find patterns in data that we might not otherwise see, so that while something by itself might not disclose something that is a communication, a pattern or a series of information that we can see as a consequence of many pieces of information might in fact be a disclosure, an inadvertent disclosure of something that is privileged. A breach of the duty confers on a client a right of action against their lawyer, both in tort or in contract, and possibly both. So clearly, lawyers and law firms take the duty of confidentiality and the duty of the doctrine of privilege very seriously. The insurers of law firms, struggling with my words today, the insurers of law firms also take this very seriously, and it is something that all law firms will have or should have, as part of being a competent lawyer, as part of the duty of competence, a system for maintaining the confidentiality and security of privileged information, of ensuring that information that is privileged is recorded, is identified as being privileged, and is stored appropriately. Now, you'll see, every second email that you get will have a little statement in the bottom of it saying that this information might be subject to legal professional privilege. Again, you'll notice through Del Pont and some of the other reading that alone may not be enough to protect it, because when it is indiscriminately applied to everything that goes out, being able to satisfy that the dominant purpose of, particularly in a litigation privilege sense, of the communication related to advice is very, very significant. It's also worth noting that one of the things that makes this complex for lawyers, that if you make an illegitimate claim that you're not going to release something because it may be privileged, and the court finds that you are doing so as a delaying tactic, that itself might be a breach of one's duty to the court, because it could be seen to be, or could in fact be, an abusive process. So again, something that seems quite simple in practice can be really complex to manage, particularly in significant issue and complex legal issues. So because the privilege belongs to the client, it's only the client who can waive that privilege. So a client can waive the privilege expressly, so by intentionally disclosing that material themselves or authorising their lawyer to do so. So this is intentional or express waiver. You'll see that cases will also look at the extent to which a waiver of privilege has been made with informed consent. Again, going back to that moral hazard question, does the client actually understand what the consequences of the waiver could be? So if a lawyer releases the information under that authorization, the client will be bound, even if the authorization is ostensible as opposed to actual. So if there's an implied waiver, or if the authority to do so is not actually in writing, it's not an express authorization. Privilege can also be lost where there's implied or imputed waiver because some conduct on the part of the client, or their lawyer for that matter, and this will occur when it becomes unfair for the opponent to maintain the privilege. So look for these themes as you do the do the reading. Make sure that you're aware of which cases support which kinds of arguments. Del Pont will go through them all in some detail. And again, because these are the kinds of questions that will likely, no promises made here, but will likely come up in exams or regularly come up in exams. And also they're pretty important to deal with in your real life. So, scope of the obligation. So it's also worth noting that the obligation to maintain a client's confidence is often a contractual obligation. So as a matter of contract, as a consequence of the retainers that we have with our clients, effectively we are promising all information that we receive in the course of acting for our clients will be maintained in confidence. Now, clearly there will be exceptions to this. And, often you need a lawyer to protect you from your lawyer. The terms of the written retainer could set out what those exceptions are. So, for example, I will often include in a retainer with my clients that the existence of the contract between us can be disclosed for certain purpose. So the fact that you are getting legal advice from me can be disclosed. For example, if you don't pay your bill and I decide to instruct a debt collector or bring an action against you to recover the amounts of money that you owe me. Also, under contract, the status of the obligation to maintain confidentiality could change when the contract ends. So the fact that you want to do this particular deal is confidential, but when the deal is documented and signed and closed, then at that point, it'll no longer be confidential. I can tell the world that I acted for you. You're going to tell the world about your deal anyway, and our retainer is open. So effectively, the nature of the confidentiality obligations will depend on the terms of the contract. But we also have obligations in equity. And in equity, in the equitable doctrine of confidentiality, information that's communicated for a limited purpose and is not public knowledge will be important. So it will be confidential. It's more limited in scope, but the scope or the obligation is more likely to continue after the retainer is complete. I mentioned before, and I don't want to go into them in any more details now, but the importance of checking out the Evidence Act and looking at, in particular, Section 119 and 131A. And I would strongly recommend that you have copies of those available to you in your exam notes. Okay, so as I said right at the very beginning, I want to finish this lecture by asking you to watch a video. Now, the video is available on YouTube, especially for those listening as a podcast. If you want to see the pictures as well, I would suggest that you actually look at it rather than just listen to it. But you get the core of the information here. Why am I including this? I've mentioned before, it's old and it's American, different rules, who cares? Well, actually, it is actually about caring. I think it's a particularly good case study for providing an example of a situation where there is a real dilemma, a choice between two wrongs. Of course, the key facts happened back in the 1980s when there was very little, if any, consideration given to the mental health of the lawyers who are involved in these proceedings. I actually have a great deal of empathy for these lawyers. Now, that might say a bit about my own ethical lens. I really feel for them, and I genuinely think that they did the right thing, but I recognise just what a difficult situation that they were in. Others of you may completely disagree with me. You may not think that they did the right thing and might zealously find ways that they might have got around the rules. The purpose of giving you this case study is to ask you to think about this issue and think about, well, what would your fire escape plan be? How would you fit your own mask before assisting others here? Because ethics is not only about doing the right thing, it's about also maintaining one's relationship with oneself as a good and ethical person, which is why these ethical frameworks that we keep coming back to, I think, are a really powerful lens through which looking at these things. Be really interested in any thoughts, insights that you might have, and as always, questions, concerns, frustrations, compliments, any of these, share them with me, share them with your tutor, and I look forward to hearing what you think. Cheers.
This is a story about an innocent man who languished in prison for 26 years while two attorneys who knew he was innocent stayed silent. As we first reported earlier this year, they did so because they felt they had no choice. Alton Logan was convicted of killing a security guard at a McDonald's in Chicago way back in 1982. Police arrested him after a tip and got 3 eyewitnesses to identify him, even though Logan, his mother, and his brother all testified he was at home asleep when the murder occurred. But a jury found him guilty of murder. Now, new evidence reveals that Logan did not commit that murder, something that was not new to those two attorneys who knew it all along but say they couldn't speak out until now. Alton Logan's story cuts to the core of America's justice system. We met Alton Logan in prison. Mr. Logan.
How you doing?
He spent half of his life here. Do you still count the months and the days?
There's no need to count the months and the days. Just count the years.
You must have been angry a lot during this time.
So I'd say the first 5-6 years, I was consumed by anger. Then it comes to the realization that why be angry over something you can't control?
Did you commit that murder?
No, I did not.
What did you think when you were arrested for that murder?
I thought they was crazy.
These two attorneys, Dale Coventry and Jamie Kuntz, knew Logan had good reason to think that. Why? Because they knew he was innocent. And they knew that because their client, Andrew Wilson, who they were defending for killing 2 policemen, confessed to them that he had also killed the security guard at McDonald's. That's the crime that Logan was charged with.
We got information that Wilson was the guy and not Alton Logan. This was just a month after Wilson had been arrested. So we went over to the jail immediately almost and said, "Is that true? Was that you?" And he said, "Yep, it was me."
Just as casually as you just said it?
Yes.
Yeah, he sort of, just about hugged himself and smiled. I mean, he was kind of gleeful about it. It was a very strange response.
How did you interpret that response?
It was true, and that he was tickled pink.
He was pleased that the wrong guy had been charged. It was like a game that he'd gotten away with something. But there was just no doubt whatsoever that it was true. I mean, I said, "It was you with the shot, you killed the guy," and yes. And then he giggled.
Problem was, the killer was their client, so legally, they had to keep his secret, even though an innocent man was about to be tried for murder. I know a lot of people who would say, hey, if the guy's innocent, you've got to say so. You can't let him
The
rot
vast
because of that.
majority of the public apparently believes that. But if you check with attorneys or ethics committees or, anybody who knows the rules of conduct for attorneys, it's very, very clear. It's not morally clear, but we're in a position to where we have to maintain client confidentiality, just as a priest would or a doctor would. It's just a requirement of the law. The system wouldn't work without it.
So that was the dilemma. They couldn't speak out, they felt, but how could they remain silent? Well, did you contemplate doing something about it?
We wrote out an affidavit. We made an affidavit that we had gotten information through privileged sources that Alton Logan was not, in fact, guilty of killing the officer, that, in fact, somebody else did.
But we wanted to put in writing to memorialize, to get a notarized record of the fact that we had this information back then. So that if, 20 years later, 10 years later, if something allowed us to talk, as we are now, we could at least, we'd at least have an answer to someone who said, "You're just making this up now."
They sealed the affidavit in an envelope and put the envelope in a lockbox to keep it safe under Dale Coventry's bed. While the attorneys kept silent about Logan's innocence, the jury, in this courthouse, convicted him of murder. Then the jurors had to decide whether to sentence him to death.
I was in court the day they were dealing with the death penalty.
Why did you go to court?
Because I had this information that this innocent guy was up there and the jury was deciding whether they're going to kill him or not.
How did you feel when you went into the courtroom? Was your heart racing?
Oh, yeah. It was just creepy. I was looking at the jurors thinking, my God, they're going to decide to kill the wrong guy.
And the jury decided?
They decided not to kill him.
It was a 10-2 vote. 10 for, 2 against. 2 individuals saved my life.
And saved Clinton Coventry from coming forward.
We thought that somehow we would stop at least the execution. We weren't going to let that go.
But instead he was sentenced to life in prison. And you did not do anything.
Right.
So it was okay to prevent his execution, if necessary, but it was not okay to prevent his going to prison for the rest of his life.
Morally, there's very little difference, and we're torn about that. But in terms of the canons of ethics, there is a difference. You can prevent a death.
But the minute he was not sentenced to death, the minute he was sentenced to life in prison, you decided to do nothing.
Yes.
You explain it.
I can't explain it. I don't know why that made the difference, but I know it did.
There's no difference between life in prison and a death penalty. None whatsoever. Both are a sentence of death.
The 2 attorneys said they couldn't speak up because they couldn't betray their client.
Right?
Can you sympathize with that?
Yes. Sympathize with it, yes. Understand it, no. Because if you know this is an innocent person, why would you allow an innocent person to be prosecuted, convicted, sent to prison for all these years?
What did you do to see if there might be some loophole to get everyone out of this fix?
I researched the ethics of the attorney-client privilege as much as I could. I contacted people who are involved with making those determinations. I know Jamie did the same thing.
I could not figure out a way, and still cannot figure out a way, how we could have done anything to help Alton Logan that would not have put Andrew Wilson in jeopardy of another capital case.
Couldn't you have leaked it to somebody, to a reporter, to an administrator, to the governor, to somebody?
The only thing we could have leaked is that Andrew Wilson confessed to us. And how could we leak that to anybody without putting him in jeopardy? It may cause us to lose some sleep, but I'd lose more sleep if I had put Andrew Wilson's neck in the noose.
He was guilty and Logan was not, so yes, his head should be in the noose and Logan should go free. It's perfectly obvious to somebody who isn't a lawyer. Andrew Wilson was guilty, was he not?
Yes. And that's up to the system to decide. It's not up to me as his lawyer to decide that he was guilty and so he should be punished and Logan should go free.
Do you think you might have been disbarred for doing that? For violating attorney-client privilege?
I don't think I considered that as much as I considered my responsibility to my client. I was very concerned to protect him.
But here was a case where two men, you two, were caught up in this bind and chose to let a man rot away in jail.
It seems that way. But had we come forward right away, aside from violating our own client's privilege and putting him in jeopardy, would the information that we had have been valued? Would anybody have done anything?
Probably not, they say, because as a violation of attorney-client privilege, it never would have been allowed in court. They insist that for them, there was no way out.
In terms of my conscience is that I did the right thing. Do I feel bad about Logan? Absolutely, I feel bad about Logan.
The two attorneys say they were so tormented over Logan's imprisonment that they convinced Wilson to let them reveal that Wilson was the real killer after Wilson's death. Late last year, Wilson died. The two attorneys finally took that affidavit out of the lockbox and contacted Logan's lawyer. Public defender Harold Winston had already been trying to get Logan a new trial. He'd found two eyewitnesses who swore Logan was not the killer. Now, with Kuntz and Coventry's affidavit, he thinks Logan will finally go free.
I know the Attorney General's office of Illinois is considering this. I have a lot of respect for that office, and I'm hoping they will come to the right conclusion that a mistake has been made. And if they do that, he would go free.
And even though Harold Winston represents Alton Logan, he agrees the two attorneys had to remain silent until Wilson died.
I wish there had been a way this could have come out earlier. Under the Illinois Ethics Code, I think the only way would have been if Andrew Wilson had released his lawyers earlier.
There may be other attorneys who have similar secrets that they're keeping. I don't want to be too defensive about this, but what makes this case so different is that Dale and I came forward, and that Dale had the good sense to talk to Wilson before his death and get his permission. If you die, can we talk? Without that, we wouldn't be here today.
See, I never stopped giving up hope. I've always believed that one day somebody's going to come forth and tell the truth, but I didn't know when.
If you were to meet up with Logan, if you were visiting him in his cell, what would you say to him?
There's nothing you can't say. I mean, it's been difficult for us, but there's no comparison whatsoever to what it's been for this poor guy.
How has it been difficult for them?
Alton, whether or not you can understand it, we've been hurting for you for 26 years.
How much does it hurt?
How often did I think about it? Probably 250 times a year. I mean, I thought about it regularly.
Everything that was dear to me is gone.
You missed the funeral of your mother.
Yes.
Okay, so, wow, hey? There's more to that video. The link will be there, but I think the relevant things for our purposes are all really in that first 10 minutes. A couple of things for you to think about is, what difference does it make that we don't have a death penalty? How would that impact your thinking about this particular scenario? What exceptions are there? Make sure that you're clear on what the exceptions are to this rule of confidentiality, and that basis on which we can take action to prevent harm, those kind of carve-outs. Look for those when you're doing the readings. But really, as much as you can, my advice as you do the readings is try every now and then to just stop, take a deep breath and think, what does that mean for me? What does that mean for the way that I am going to have to segment and organize my thoughts and my life going forward? I think it's really interesting to think about that and to kind of settle your position in advance rather than get caught up in it too quickly. Good luck with the readings this week. We're starting to really get more into the law rather than technology stuff. So for many of you, this will be a happy place, reading a case, reading a textbook. For others, possibly the ones who should reconsider the law, reading cases might be a little bit more difficult. But I'm sure you'll all do really well. I'm looking forward to giving you some feedback shortly on your assignment. We will see each other in a couple of weeks because you will find that there's a break in between. Take care. Cheers.